This is simply a hearing about whether Board of Elections members must follow instructions issued by the Secretary of State. In his directive, Secretary of State Husted made sure that regardless of where an individual lives in the state of Ohio, that individual will have equal, fair access to early in-person voting hours. He set hours across the state that would be one and the same. What we've heard today is justification, attempted justification for the blatant disregard of 2012-35. 2012-35 is not unclear. It is clear. It says these are the hours that boards of elections are to be open. It applies everywhere in the state. It applies uniformly in the state. It applies so that voters in any county will be treated the same. But what we have now are two board members who have attempted to disregard the clear direction from the Secretary of State and to turn their justification by claiming that there's some unknown ambiguity that no reasonable person reading the directive would find. Your Honor, that ambiguity would be much like having a teenage daughter and telling your teenage daughter that on Friday night your curfew is 11 p.m. I expect you home at 11 o'clock. And sure enough, your teenage daughter listens to you. She comes home at 11. And at 12:01 a.m., she heads out the door and back to the party because, well, it's not Friday anymore. It's Saturday. And you never told me anything when you told me that my curfew was 11 o'clock on Friday that said, well, I couldn't turn around Saturday morning first thing and leave again. That's what the argument we've heard today. And it is clearly not permissible under this directive.
I would also tell my two teenage daughters that they were not entitled to the protection of various sections of the revised code that I'm about to review, okay, which apply to board members. Parents can be arbitrary. The Secretary of State cannot be. He has to follow the law. And my daughters are also not entitled to the constitutional protection of the Ohio Constitution, which says that appointed public officers may not be removed except for cause and it has to be shown in a hearing, due process hearing. There has to be just cause for their removal to comply with the Ohio Constitution. Now, statutes that are relevant, I'm going to discuss those as quickly as I can and then discuss the context. Lots of people around the state, including my two clients, and apparently at least 21 other boards of elections, that believe that there should be additional voting or weekend voting. We have situations where, you know, Mr. Husted was faced with having to break tie vote decisions, or some cases it wasn't coming as a tie vote. And I understand that. That's described in his background. So there are different, people are doing different things. There are different opinions about what should be done. And then we have, essentially out of the blue, we have a directive by the Secretary of State's office, which simply wasn't, it was a rush job. When you have a rush job, you make mistakes. You don't write it as tightly. You don't bounce it off enough people about how this could be interpreted, you know, contrary to perhaps what your intended outcome is. There's a rush job, and well, I don't fault him for what he did. I fault for the fact that it resulted in ambiguity, and also fault him for the fact that now he's trying to use that to discipline these two board members. At the same time, even though that letter, that to meet and rescind was directed to all 4 board members, we only have these 2 here. So to the extent that you're going to consider that as nonfeasance, not taking any action at the afternoon meeting, where are the other 2 board members? Why aren't they brought up on charges? So I think for all these reasons, that you should find that there is not grounds for finding nonfeasance by these 2 individuals. And I'd be happy to try to answer any questions.
Just a short.
Short.
Let me start with the one section of 350105 Mr. McTighe did not talk about that is at issue. And that is 350105C. Prepare rules and instruction for the conduct of elections. It's very clear that Directive 2012-35 is a rule and instruction for the conduct of an election, namely, what hours is the Board of Election going to be open for early in-person voting. Mr. McTighe is talking about the Open Meetings Act. Yet he does recognize that emergency meetings do not require a 24-hour notice. This was an emergency meeting, and it was clear that notice was given out. Why is this an emergency? As of right now, we are 77 days from the election, presidential election, which historically always has the highest turnout. Presidential general election always has the highest turnout. It is necessary for the board to follow the instruction of the Secretary of State. That is what they were told to do in the directive. That is what they were told to do in the Dan Schroeder letter. It's ample ground for an emergency meeting in that type of situation. We keep hearing this referred to as a motion to follow the directive. It's not a motion to follow the directive. It's a motion to follow and not follow the directive. Okay, fine, we will do this, but we're still going to do something else. Your Honor, I started out in my initial comments talking about the teenage daughter who decides if she comes back by 11 and then leaves at 12:01, she's following the letter of the law, so to speak. I mean, we can talk about, if we look at this directive, it says 8 a.m. to 5 p.m. You know, Your Honor, it doesn't specify Eastern Standard Time. Does that mean that we can go ahead and have a Board of Elections decide to use Greenwich Mean Time for the hours that they're going to be open? I grew up in a neighborhood, Your Honor, that had a lot of Greek and Serbian neighbors. And it was always fun because, you know, the week after we celebrated Christmas, they would have Orthodox Christmas because they were on a different calendar than we were. Well, you know, this directive doesn't say October 2nd Gregorian calendar. So can a board decide that they can use the Julian calendar to start deciding which days they're going to be open? Of course not. That is why the reading that Mr. McTighe is trying to advance of this directive is completely and totally
Time, your civility today. I will take this matter under advisement, including all the exhibits that have been brought into the record, as well as objections that were raised. I am shooting for having something back to the Secretary of State by the end of the week. Some of that will depend upon the record coming in, not only from the court reporter, but also we also need the transcript from the Friday afternoon meeting from the Montgomery County Board. That will this hearing, and I appreciate your attention.